So hello, everyone. I think it's just past 2, so we're going to start now. So good afternoon, everyone. My name is Divya Khurana. I am counsel at the Barbara Schleifer Clinic, and it is my distinct pleasure to be your moderator for today's event. So I'm going to start by introducing our wonderful panelists who volunteered their time today. So on my screen, we've got Sona. Sona Advani is currently Senior Counsel with the Court Services Division of the Ministry of the Attorney General. Prior to that, she's been both the Acting Legal Director at the Civil Remedies for Illicit Activities Office and an Assistant Crown Attorney with the Downtown Toronto office. She's a longstanding member of SABA Toronto and has served on the board for numerous years.
Thanks, Divya.
Hi, Sona.
Hi, everyone.
So we've got next up Munaf Mohammed, who is joining us from Calgary. Munaf is national co-head of the Bennett Jones Calgary office fraud law practice and maintains a national litigation practice with a strong emphasis on civil fraud and international asset recovery claims. If you are interested in learning more about Munaf, I have to say I could not do his bio justice. Please look all of our wonderful panelists up. There is much more to learn about them than I can tell you today. But with over 60 reported cases, Munaf has extensive trial and appellate experience. And since articling with the Alberta Court of Appeal and Court of Queen's Bench, he's appeared as lead counsel at various levels of court in numerous jurisdictions and has appeared before the Supreme Court of Canada on multiple occasions. Among his other accolades, Munaf has been repeatedly selected by Benchmark Litigation as one of the top 50 trial lawyers in Canada. And of course, we are then joined by Justice Ghosh. Justice Amit Ghosh was called to the Bar of Ontario in 2002. That would have been remarkable, 2012. He began his legal career at the full-time federal Crown Attorney Agent for the Department of Justice in New York region and had a small criminal defense practice. In 2004, His Honor joined the Ministry of the Attorney General as an Assistant Crown Attorney with the Crown Attorney's Office in New York region. Over the next decade, he prosecuted a wide array of criminal code offenses, including homicides and wiretap investigation. His Honor accepted a position as counsel to the Regional Director of Crown Operations in 2014, where he advised the director and was assigned special prosecutions. Justice Ghosh was then appointed to the bench at the Ontario Court of Justice in 2015. So thank you all to our panelists for joining us. We have a wonderful program today. Sona will be leading us off by starting with an overview of cross-examination, including trial preparation, how to identify the theory of the case, and determining the goal of cross-examination for each witness. She will also be providing us examples on how to prepare your notes for cross-examination, the format of cross-examination questions, and the lawyer's role during cross-examination. We will then have the opportunity to hear from Munaf, who will cover strategic and substantive aspects of cross-examination, including strategic considerations on how to structure a cross, the rule in Brown versus Dunn, impeachment, when and why, strategic and evidentiary considerations on expert witnesses versus lay witnesses and difficult witnesses. And last, but certainly not least, we will have the opportunity to hear from Justice Ghosh, who will be providing us perspective from the bench on effective cross-examination. So we will have the opportunity at the end of the program for questions. I encourage participants to please send their questions directly to me in the chat box. I will then make sure to monitor the chat box to pose these questions to our speakers at the very end of all of their presentations. So please go ahead and lead us off, Sona.
Great, thank you so much, Divya. Thank you also to SABA and the organizers of this webinar for inviting me to participate in the webinar. I'm happy to be able to join my esteemed colleagues, co-panelists, and all of you again this year, as we unfortunately continue to grapple with the COVID-19 challenge. On that note, I hope everyone's staying safe and sound. Hard to believe it's been over a year, but fortunately we're able to proceed with the webinar in the format that we have it today. So as Divya mentioned, I'm a former Assistant Crown Attorney and have remained close to litigation ever since. And today my goal is to share what I've learned from my experiences, and I'm hopeful that you will find what I have to say to be useful in your own practices. I will also be periodically asking my co-panelists to comment on their approaches to the issues that I'm about to discuss. So before we get into the nuts and bolts of cross-examinations, I thought it would be helpful to take a step back, start at the beginning, and talk first about trial preparation. So preparing for your trial and knowing your case will shape every piece of advocacy you do in that trial, starting from the opening through to witness examinations to your closing. It is imperative you become familiar with all of the evidence in your case before you embark on preparing any one witness's examination. Winging a trial or an examination may look great on TV, but not so much in real life. I suggest that you make sure you know what it is you're trying to prove or establish or negate. What is your theory of the case? What are you trying to establish? And how do each of your... So, for example, the theory of your case could be that the lighting in the front of the house, and I'm using a criminal context case, where the offense occurred was too weak for an accurate identification of the perpetrator to be made. This is the theory you're working towards in every step you take in your case, in every examination that you undertake. You must know the evidence in your case, all of it, the harmful parts and the parts that help you. And before you embark on the cross-examination, look carefully at each witness and the role they play in furthering your theory of the case. How does this witness fit in within your theory of the case? What is the witness going to say? And how can you challenge it to further your theory? If you're a defense counsel, your job is to raise doubt in relation to the essential elements of the offense at issue. So then you want to think about how this witness can assist you in the pursuit of that mission. Next, you must know the witness's evidence, not only what they are going to say, but what they aren't going to say or cannot say, and how this witness's evidence interplays with the evidence of the other witnesses in the case. Figure out what your goal is in cross-examining this witness. Is it an attack on the witness's credibility? Is it to have the witness deliver key facts that you will not be able to obtain from the other witnesses? Or is it to challenge the accuracy of the witness's testimony based on lack of ability to observe, the passage of time, or bias, or defects with memory? So, for example, if you have a witness who is an identification witness in your criminal case, you are expecting them to testify about, say, the 4 lamps at the front of the house and how they offered sufficient and ample lighting to accurately identify who the perpetrator was. Your goal with this witness is going to be to challenge the accuracy of their observation by attempting to refute that a proper identification could be made with that level of lighting, therefore raising a doubt in relation to the accuracy of the identification. One of the lamps was burnt out, or the lighting precisely where the offense occurred was too dim, there were shadows interfering, or perhaps there was an obstruction in view. Again, this approach demands that you know the precise details of the witness's evidence, along with the anticipated evidence of the other witnesses in the case, as they will all work together to build the puzzle. Remember, not only do you need to know the witness's evidence, but you also must know where to find the evidence if you need to refer to it during the course of your cross-examination. So what if you have to impeach a witness during their cross-examination? Do you know where to quickly find the relevant statement or transcript to do that? So this would be an issue of organizing either your trial binder, your trial file on your laptop, or in my case, a trial box. Do you want to color code it? Do you want to highlight certain portions, separate it into folders? It's up to you, but again, you want to know your case and your file well enough to know what you need quickly and effectively while on your feet in the middle of your examination. Beyond knowing the evidence, you must also know the rules of evidence that apply in your case. What can you ask about? What must you ask about in cross-examination? And here I'm referring to the rule in Brown and Dunn, which will be touched later on by my co-panelists. What has been ruled inadmissible in pretrial motions or already been consented to? What must you avoid? Why must you avoid it? In the event it comes up, you have to be prepared to be able to explain why you did what you did or didn't do what you did. This knowledge will also inform the objections you can make. Before I turn to cross-examinations in general, I'll turn it over to my co-panelists to see if they have any comments on the theory of the case or how to determine the goal of cross-examination. Justice Ghosh, Manav?
If you like, Manav, go ahead. You can go first.
Thanks, Sona. So I just would add this. The way I look at a cross-examination, and I'm going to be the odd person out on this panel, I don't do any criminal law, so everything you hear from me is going to be in the civil context. But my approach to cross-examination is, picture you are in a warehouse and there are 8 doors and the witness is sitting in the middle of the warehouse. The witness can run faster than you can. You have more stamina. And if you go directly to that witness will head for an exit door and they're gone. So when I sit and think about a cross-examination, the goal is to go around the warehouse and lock all the doors first, then go chase the witness. And that helps in terms of the overall view of what a cross-examination is and what you're trying to accomplish. And I agree with what Sona says. I mean, you're from the civil perspective, my goal is typically one of 3 things. I want to obtain admissions from the witness that might be helpful to my case. I want to attack the other side's case and see if I can reduce it in some way. And I want to approach the issue, obviously, of credibility. And it's not just to attack the credibility. In some cases, you may want to bolster the credibility of the other side's witness. And so those are sort of the big picture things that I have in mind.
I'll pick up on that. Thanks, Munaf. I agree with all of Sona and Munaf's observations about constructing a coherent theory of the case. I'll elaborate a bit at the end when it's my turn, but I think a theory of the case is essential before you commence constructing a draft cross-examination. And it can only come after a very detailed examination of the file and a working knowledge of the file. And that will include any examination or investigations you commission. You really got to know the case inside and out before you construct your theory. You can have complementary theories, that's fine, provided they are all geared towards an ultimate overarching aim, which is to achieve a certain result from the trier of fact on behalf of your client. So I'll say more when I'm up.
Divya, any comments?
No, I mean, I think you've covered it all. I'm going to let you continue and save some questions for the end.
Okay, thank you. So let's turn then, everyone, to preparing for your cross-examination. So as you know, generally, cross-examination is the leading questioning of your opponent's witness to strengthen your own case. This is done with the view to covering off the necessary topics to achieve the specific goal you are targeting with a specific witness, with the ultimate purpose being to advance the theory of your case. The focus of this examination, in my view, is the lawyer and not the witness. The key, in my view, to cross-examination is to simply have the witness agree with you. Check, check, check. It's almost irrelevant what the witness is saying. In most cross-examinations, there are specific examples and exceptions, as there are in every case. And there are many pitfalls in planning and structuring your cross-examination. And again, before embarking on the examination, my recommendation, as always, is that you be prepared for it. And that brings us to the use of notes. Do you need them? My answer to that would be a resounding yes. While trials may be an exercise in theater, I would argue that they are not an exercise in improv theater. So what should your notes look like? There are certainly different schools of thought on this, and I don't think there is a right or wrong answer. And I expect both my co-panelists may have different approaches as well. But it really is up to you with the view to increasing your comfort level in terms of being and feeling prepared to embark on your cross-examination. So it is suggested that you adapt them to your own style. What I've done is I've provided an example to Divya of what I do in my trials. And if Divya, if I could ask you to please share the example, I can go through how I normally set up my notes page when I'm doing cross-examination. So this is just my opinion of how a notes page can be set up. So I do one topic per sheet or sheet. I don't write out verbatim questions, but rather I put the main heading of the area of questions that I want to ask the witness. And then I note down the answers I'm expecting to of the question. So for lamps, shadow cast by card, just keeping in with my example that I started on earlier. And then I ensure that I have the source of these answers in the left margin of my page, so I know where to readily access them if the witness answers something different than what I'm expecting and I'm about to embark on an impeachment. So for example, I would have something like, preliminary hearing transcript, volume 3, page 13, line 7, to correlate to the answer that I'm expecting. In the right margin, I take down any key notes from the witness's testimony, including where their answer is different from the one I was expecting, or where there's additional information that I hadn't accounted for or that can't be sourced in any of the previous evidence. And then finally, just to keep myself on track so I don't lose sight of what it is I'm trying to achieve overall, I put the goal of this witness's cross-examination at the bottom of the page. So again, this is just an example of the process that I generally undertake when I'm preparing for cross-examination of different witnesses. And again, it need not be yours, but I thought I would share it in case it's of some help. Thanks, Divya. This might be a good chance for me to turn to my co-panelists to see if they have any comments with respect to their process in terms of note setup, or if they use notes at all.
I can jump in here for a second, if that's all right. So, Sona, that was very helpful. And I'm curious to know, in the way you would construct an anticipated cross, and it permits a lot of dynamism in the way you've structured it, how much of that is informed by the area of practice that you came from? We came from a Crown background, and we are expected to cross-examine. We have to, by nature of the role. You cross-examine extemporaneously. You get a feel for what the witness says. You don't know what's coming at you, and the ability to prepare with some precision is not as readily available as it might be in other disciplines. Can you comment a bit about that?
So you're absolutely right, Justice Coach. That is very much my criminal cross-examination note setup. I find that in my short dabble with civil litigation, the cross-examination setup was far different. It wasn't quite as high level overview. There was far more detail because I was privy to a lot more information in advance of the actual trial than I would have been with criminal trials. So I completely agree. It is a function of practice area, but I think in terms of sort of key elements, it can be used to guide other setups for other different practice areas.
I totally agree. It's incredibly helpful.
Thank you.
And it's not unlike what I would try to do. Munaf, I wonder if you've got a more granular approach because of the nature of your practice.
I do. I agree completely that standing up and winging it is not a recipe for success. And maybe what I would do, if it's okay, is when I get to how I structure a cross, I don't want to burn up a bunch of time that while Sona's going through stuff, but I do it quite differently, and it is very granular. And with depending on the type of case, the cross examinations will take days. And so to just in terms of setting it out, I can go through sort of the intricacies of how I do it. I don't think there's as Sona said, there is no right way. My sort of view on cross-examination is 80% of it can be taught, 20% is in you, and you'll figure it out by watching others, listening to others, and then doing it. So
I can say for a lot of our participants, I think that's probably a relief to hear that 80% can be taught enough. So thank you for that encouragement. But I think that, all of you touched on it, that preparation is absolutely key. The style that you take doesn't necessarily always matter as long as it makes sense to you, but preparation is very important. So Sona, go ahead and lead us off into the next area.
Well, thank you so much, Divya. And you're absolutely right. So what I'm hoping to give here is just some of the structural background to help guide how you prepare your cross-examination. As everyone's identified, there is no right or wrong answer. And some of it is stylistic, and you'll take away and develop your own style as you develop your experience as well. But for me, these are some of the background tips, things that I did in advance that helped me, and I'm sharing them with you on that basis. So then turning to the actual examination, so we're still not there. We're asking questions. We're still working through how we're going to do our setup, what the goal is, what the theory is. what the notes look like. And then in terms of your outline, what is it that you need this witness to say? And more importantly, how are you going to get them to say it? In cross-examination, you're looking at an adverse witness whose first job is not to help you with this trial. So you want to be careful about how you're structuring your outline, what your outline is, what you're looking to get from this witness, and ensure that you also think about how that answer will come to you. You want to think about the structure of the order of your questions. Will you do it thematically? Will it be done in a narrative chronologically? Or is there some other strategy that you want to fashion? You do want to think about being persuasive no matter what your structure is. You want to make sure that you're not losing the interest of your trier, so that you're staying persuasive, you're staying interesting, but you're also staying comprehensive so that the trier is not immediately lost in your cross-examination outline. You also want to think about not jumping awkwardly from topic to topic. And Munaf will speak some more about specific strategies on how to structure your cross, so I'll leave it at that. But I will say you also want to be careful about providing too clear a roadmap to the witness so that they can easily anticipate when the big bang fireworks are coming and quickly diffuse them before you can get to them. Think about making your roadmap clear maybe in your argument at the end where the witness does not have the same opportunity to respond, but the trier has your undivided attention and can follow along your roadmap. Think about primacy and recency. So what I mean about that is that think about which section of your cross-examination will come first, which one you may end with in terms of making the most impact, the biggest bang, or leaving the effect the most with your trier. You might want to consider structuring your cross-examinations. You're ending on a high note with a big flourish, sitting back down at your desk. Think about an exit strategy aside from slinking away with your tail between your legs if the cross-examination doesn't go quite the way you had envisioned it might. In terms of the general format, and again, these are general principles for formatting your questions, remember some of the key rules, which most of you must be familiar with. You're generally asking leading questions or leading statements, proposition. Ideally, you're looking to ask a question to which the answer really is unnecessary, in the sense that you're the one that's providing the witness the answer and you're hoping that they will agree. This is, again, general principles, not true in every single question that you ask. In terms of control, the object is to control the witness, not have him or her control you. And I know Munaf will speak to us a bit more about control, but for now, I wanted again to note the focus is not on the witness in cross-examination, it is on you as the lawyer who is leading the evidence and again, having the witness simply agree along. Now, this doesn't mean shy away from open-ended questions. There's much to be gained from asking open-ended questions. There are many windfalls that may be achieved. And again, there might be rhetorical questions that don't really need an answer, but just be strategic on when you are using open-ended questions and be confident that the answer cannot destroy your case. I would suggest that you try and establish one fact per question. Lengthy, confusing questions make for confusing answers. I would suggest the best way to structure your cross is to keep your questions simple, and the best way might be to focus on one fact per question. Similarly, keep your questions short. Avoid complicated or legalese language. It will impress no one. I bet you wouldn't impress the trier, but Justice Ghosh will tell us more about how impressed he is with legalese questions. Avoid compound questions where you can get multiple yes or no answers. There are too many questions built into one, and the answer is confusing and makes sense to nobody. Avoid repeating the same question. It will certainly frustrate the judge because you're wasting everybody's time. And usually asking the same question with hopes for a different answer doesn't work. And I would suggest the tip that I've availed myself of many a time is asking for recess after the completion of the examination in chief to ensure that you have your thoughts organized, especially if you're crossing a witness whose evidence you've just heard for the first time, which is part and parcel in the criminal prosecution world, where there is no reciprocal disclosure and you have no idea what the accused person or any of the defense witnesses are going to say until they hit the box. A recess to collect your thoughts and maybe jot down your points and your questions will likely be more effective in getting your cross-examination to be a bit more thought out and organized. It will likely avoid you having to ask questions more than once, or asking questions to which you don't know the answer. And then finally, I would say, don't ask the one question too many. If you get a good answer, move on, get on to another topic before the witness can qualify the answer when you ask that one question too many. So those are just a few highlight tips that I would suggest you keep in mind when structuring your cross-examination. Again, there is scope for shifting away from these tips, but generally I would suggest these are some of the pointers to follow at best. I'll turn it over to Justice Ghosh and Munoz to comment at this point before I move on to the lawyer's role.
Sure. The only thing I might say on the civil side, I do perhaps a little differently is as soon as the other side is finished with the witness, I will typically jump up and ask a question, even if it's only for a few minutes. And the reason I do that is I want to foreclose the ability of the witness to speak to their lawyer. And so if we take a break after the exam in chief, if there's something that's come out that's a problem, the lawyer still has the ability to talk to his or her witness. And so I will typically stand up, take the lectern, and immediately get started with at least a few questions. And then at that point, ask for the caution from the judge, advising the witness that they're not at liberty to discuss their evidence with anyone else. And that way I've got them boxed in, not to get any help.
There's immense value to doing that. And, depending on your comfort level, you may decide that, well, that's tactically wise of me, but I really need to gather my thoughts. So you'll decide what's right for you. But there is an incredible appeal to Manaf's approach because it does close off any prospect of consultation, and you want to shut that down if you can. So there's value to that. I really like the way Sona summarized the various approaches. I'll dig in a little bit later on there is no right way. There's no set approach to organizing your cross-examination or structuring it. You might want to hit them with the big fireworks near the end or right at the start, because it may erode the trier of fact's confidence in the witness after hearing all of this facially reasonable testimony in chief. So you'll have to decide, depending on the case and your comfort level, how you want to approach each unique cross. And each case may call for a different approach. Each witness may call for a different approach. And we'll talk a bit about that as well. But I really like the way Sona sort of framed the various approaches that might be receptive. Just always keep in mind, at the end of the day, you might be putting on a bit of a show for your client or the witness. You're ultimately trying to prove your theory and establish your case in final submissions to the judge or the trier of fact. So just keep the end game in mind.
Great, thank you both. I'll turn now briefly to what I think is the lawyer's role during cross-examination and things to keep in mind while you are on your feet conducting your cross-examination. So not to be trite, but quick reminder, don't examine crossly. That's not the goal you see, or maybe on TV or maybe in court. Unfortunately, you've seen some people that take a very aggressive attitude, aggressive approach to cross-examination, acting adversely or in a hostile manner. I would suggest that perhaps you steer clear of that. Certainly if you are starting out or even further on in your practice, I think it's best to stay composed and professional, polite. I have seen cross-examination, so to speak, attracting the ire of the judge, who finds it annoying and considers it to be badgering the witness, and the judge will not hesitate to intervene and call you on it. And I also think it proves to be a distraction from the substance of the examination, although it may look theatrical. I don't know how impactful it is. Another thing, and now I'm speaking from personal experience, is make sure you listen to the answer your witness is giving rather than being so focused on your notes or the next question that you're going to ask. So there are many times I've missed fabulous answers from witnesses, which were even better than what I could have imagined, but I didn't catch them because I was so busy thinking about what my next question was. It's very, very easy to do that, but no matter how much you think you know what the witness is going to say, they will say something unexpected, which proves to be a huge windfall, takes you down a complete different path You take your notes and you throw them over your shoulder because you've got a gold mine. So make sure that you don't miss it because you're too engrossed in your notes and your papers and your file. Similarly, the flip side is there might be something damaging that's for which there is no basis and may require some impeachment on the point. Notes are important, but don't focus so much on them that you miss an answer. Where appropriate, I would advise that you use diagrams, demonstrative and/or other technological aids to allow for a visual image to be created for the trier. Ensure these items are, of course, vetted in advance with opposing counsel so the in-court process is a smooth one, but there is much to be gained from having the picture there rather than using the 1,000 words to paint it. So think about where you're able to incorporate that in your cross-examination. And I'm sure everyone can think of an example or two, maybe from TV, where the whole case was figured out on the basis of one photograph or of one photo. Practice your cross-examination. Do a dry run with somebody that you trust. Be aware of any nervous tics that you may have. You may not realize that you're saying uh-huh or okay at the end of each of the witness's answers or at the end of each of your questions. It was a terrible habit that I had where I was saying okay every time the witness gave an answer. It sounded ridiculous. I needed a particularly assertive court reporter to provide me with a transcript where every single okay had been transcribed. I was mortified and started writing "don't say okay" on the top of each of my note pages until I finally broke myself out of the habit. But it happens. Be mindful of it in terms of crafting your skills as an advocate. This will certainly take you a long way if you're able to eliminate such fluff, filler, and these little nervous tics. Again, know when to stop or really whether to ask any questions at all. Remember your theory of the case and the goal of cross-examining this witness. If asking questions of this witness won't assist you with your case or risk making things worse for your case, then consider skipping asking this witness any questions. Just because the witness has testified, it doesn't mean that you must stand up and ask something just for the sake of it. For example, "I have no questions of this witness, Your Honor," may alert the judge that you consider the witness's evidence to be immaterial. And isn't that the best statement of all? Just be sure that you're right when you take a stance such as that. So I think I'll stop there. Those are a selection of some best practice tips that I've learned over the years for conducting your cross-examination. I will turn it over to Manaf next to talk about some of the strategic and substantive aspects of cross-examination. Of course, I'm happy to answer any questions on anything that I've spoken about. And I think, Divya, you said you want to reserve questions until the end. Is that right?
Yeah, we'll do questions at the end because there's a good chance that Justice Ghosh or Manaf will answer some of these questions.
Perfect.
So just send them to me in the chat box and we will reserve 10 minutes at the end for questions.
Great, thank you.
Great, thank you. And again, thank you for inviting me to speak at this webinar. I thought what I would do is deal with things in the following order. I was going to touch upon just how I prepare and just to build a little bit on what Sona said. I'm going to deal with then the differences in cross-examination between lay witnesses and experts and build into that, dealing with hostile witnesses, and maybe try and offer some tips that I've learned over the years in how to deal with especially experts and difficult witnesses. And then I'll turn to talk about impeachment, Brown and Dunn at the end. So first, again, and this is in the civil context, I start with the pleadings. I list out what the issues are, what I have to prove factually in terms of what the law provides. And then I'll start mechanically by summarizing transcripts. And I don't get juniors to do that. I do it myself. And the reason I do it is so that I know the evidence cold. And as I summarize, and sometimes you can have 1,000 pages of transcript for a witness, I will group the actual important parts under the topics that I've identified. Once I've done that, I've got 2 or 3 pages which have basically the evidence from the different witnesses grouped under these topics. And then I start drafting a cross-examination, and I am one of those people who does write out my question. I write it out. I'm not wedded to it, but I write it out. And the reason I do that is because I will write it out so that it is very close to what the transcript actually mirrors or what I have in a document, so that it sets me up for the impeachment. Because many times the problem is your question that you've asked is different from the answer that you get, and you try and impeach and you get into an argument about whether it's really a contradiction or whether it isn't. And so I will actually have it written out. I will have a document reference and a transcript reference. And of course, there are times when you don't have a specific reference. And what I'll do in that circumstance is try and build incrementally the cross-examination, so that, to the point that Sona made, if you get into trouble, I've got an anchor, which is right back into my cross with a question that I know I will get an answer to that I want, because I have a transcript reference and or a document reference. So I know I can grab on and control that witness. And also, when I'm dealing with that type of cross where I don't know, it is very important to try and close the doors in the warehouse. And I'll give you just a very simple example. You want the witness to acknowledge that they've read an important email that has some sort of damning admission in it. So you can say to the witness, witness, I understand you have read this email in its entirety. Now you've gone straight to the witness and they say, no, actually, I don't recall reading this one. Versus starting out by saying, witness, I understand that your email probably works the same way as mine. I gather it comes in and you see the author first, and then you see a reline. And I take it your practice then would be to open and read the email, and you would do that throughout the day. So now you've pinned the person down to say that that is their practice, that's what they do, and then ask them the question that you obviously don't have a reference to, but that you're very likely to get a positive response. Maybe with that, I can see if either Justice Ghosh or Sona have anything to add before I turn to experts and lay witnesses.
Nothing for me. Thanks, Manav.
No, I think that's incredibly helpful, especially given the nature of some of the files you must have in terms of the sheer volume of the pleadings. It resonates with me, your pursuit of, and I suspect with many in the audience, I hope, that you want to know your case inside and out. You want to know it cold to permit the sort of dynamism to deviate from the precision of the language that you may have crafted, because as Munaf intimated or said as much, the words really matter, especially when you're trying to lock down language in emails or in transcripts.
So let me just turn then to talk a little bit about the type of witness. And let me say that I always mostly will start by trying to be friendly with the witness. You know, the old adage, you're going to get more bees with honey than with vinegar. And so typically you'll start out in a very friendly way, and you stay civil and respectful. But there are times where, to the point that's been made, you will probably need to get a little more assertive in terms of controlling the witness. And I'll talk a little bit about how I do it and how I might suggest you approach it. So when I start across, I typically want to get into something that is substantive very quickly. And part of that is to get the attention, of course, of the court in terms of what we're dealing with and the issues at hand. And if possible, to see if you can get the early impeachment, which will start casting doubt on the witness. And this, of course, doesn't happen every time. So let's maybe talk a little bit about the different types of witnesses, and let's deal with difficult witnesses, and then I'll talk about experts. So you've got a witness who wants to fight with you and doesn't want to answer questions. And I agree in terms of the control, and I say this with some sort of measure of trepidation with a judge here on the panel, but my view is only one person is ever in control of that courtroom, and I know the judge will always say it's him or her. I would take issue with that. I'd say the cross-examiner should control the courtroom. And don't let the witness control the courtroom, don't let the judge control the courtroom, and don't let the other side control the courtroom. And what I mean by that is you can have lawyers on the other side that will constantly jump up and object, and they interrupt, and the focus then becomes on them. You can have the difficult witness who will start asking you questions and refuse to answer. And if you take the bait, they're the ones in control. And so the way I do it, and like I say, there's many different approaches, is start with the basics. You're going to be polite and you're going to be civil. And so you ask a question and the witness obfuscates. So Mr. X, you were aware that the company was losing money in 2019. And the witness says, well, that's the CFO's job to keep track of that. So now the person has obfuscated, has refused to answer the question. What do you do? Politely, yes, no, I understand that and I appreciate that, sir. But just to be clear, you were aware that the company was losing money in 2019. The person says, well, I can't sit here and answer that for you today. You take them to the documents and you say, sir, I'm going to ask you one more time to give you an opportunity to answer directly. And after that, I'm going to ask His Honor or my Lord to direct you to answer the question. Now, let me pause there. Who's in charge when you, the lawyer, are telling the judge what the judge is going to do, and you're telling the witness what the witness is going to do? You are. And in my experience, if it's a reasonable question and the witness has been offered multiple opportunities, most judges will step in because they'll be annoyed and they will say, witness, please answer the question. Maybe I'll stop there and see if that is the experience that Justice Ghosh and so on have had.
Absolutely, and certainly no need for trepidation on that point. You're 100% correct. The cross-examiner is in control of the room and should be. So an effective cross requires command of the witness in the courtroom and signaling your confidence in your examination and representations to the witness. So that's absolutely the way to do it. You want the judge to be the recourse of last resort to intervene. You want to convey to the witness, I'm in control here. So exactly the way Munaf proposed it, you do your best, and what you're doing is also signaling to the judge that, wait, we got a difficult witness here. And so there's an advocacy element to that style of cross-examination that's very effective and will be well received by the judge. So, I mean, in the civil context, it may happen regularly, but in the criminal context, we routinely get witnesses that just are completely obstinate. They're not bound by their oath or the subpoena, and they sometimes will refuse to answer. I don't want to answer that. And and that's where, as Munaf referenced, you want to lock down what they've said, lock down what they're refusing to answer to, and then as a last resort, which is also, as Munaf said, you're signaling command to the judge as well. And I'm receptive to that when it happens, because I know exactly what's happening when the lawyer is using that strategic approach. It's totally proper and helpful and sends me a message, a valuable one that I'm receptive to. So it's something worth doing. And if I have to, I'll turn to the witness and say, look, you have to answer the question. Why? It's a combination of your oath and the subpoena. Just answer the question. And then there's other remedies after that, which almost never have to arise. So I'll turn it back to you, Mina.
Sorry, Sona, anything to add to that?
No, I completely agree. And that's certainly been my experience. So for those counsel that might be concerned about overstepping or somehow upsetting the judge, who may not be as nice as Justice Ghosh is on the bench, judges know that. They expect it. They were lawyers too. And they know that when you're being assertive and you're trying to exert control of the witness, as long as you're doing it politely and in an appropriate fashion, it's almost expected and you'll be lauded for doing that. So I completely agree with my colleague's comments. Thanks, Manaf.
let me turn then just to talk about experts versus lay witnesses. And within the context of this, I can talk about difficult expert witnesses. And the cross-examination of an expert is a very different thing than a cross-examination of a lay witness, of course. You are unlikely, with a rare exception, to know as much as the expert about his or her area. And so trying to delve into the minutia of whatever it is the expert is there to talk about is just a recipe for disaster. Unless, of course, you happen to be an expert as well in the area. So let's just talk a little bit about approach to experts. So typically, and remember what an expert is there to do. The expert is there to provide a ready-made inference to the judge based upon a set of facts that need to be proven. That's it. That's all they are there to do. And so there are, in my mind, 4 different things that you are going to focus on when you are cross-examining an expert. The first is you want to deal with the expert's qualifications to demonstrate either that the person is not qualified or is not as qualified as your expert or is not qualified within the particular narrow thing that you're dealing with. Second, you want to attack the expert witness's opinion to demonstrate either that it is mistaken or that it is just wrong. Third, you want to deal with the factual foundation that the expert opinion is based on, and I'll talk a little bit about some strategies there. And then finally, you want to deal with potential bias or interest, that is the White Burgess sort of authorities on independence of the expert. And so you want, obviously, the judge to accept your expert over the other expert. And so let's talk just a little bit about qualifications. This is an area that I think people don't cross-examine. In my experience, people will leave it alone and just admit qualifications. And I don't think it's a good idea to nitpick about qualifications, but it is always amazing to me just how much the experts in a lot of cases are not familiar with their own practice requirements, guidelines, codes of ethics. And so read and understand what their professional guidelines are and try to ring fence in the qualifications cross-examination what it is they may and may not opine upon. Be very specific. Go through, and I'll give you a good example. I was cross-examining a valuation expert recently, and there are 3 types of valuations that one can prepare: a comprehensive, an estimate, and a calculation. Comprehensive is, of course, the main one. And starting slowly with them, it's, sir, I see from your CV you've done a lot of valuations here. Yes. And sir, just can you help us? First of all, can you tell us how many of these are comprehensive valuations? None of them. Those are very rare. Oh, so sir, you've never had the opportunity to actually ever conduct a comprehensive valuation. And now what you've done is you've ring fenced in the expert's qualifications, and the judge knows this person has not done something that is sort of at the top, and presumably your expert has. So when they're comparing, yours looks better than theirs. Maybe I'll just stop there in terms of qualifications and see if there's any comment on that.
So Munaf, oh, sorry. Go ahead, Justice Ghosh.
No, I can improve on what Munaf said, beyond to observe that the qualification stage of the Moha and voir dire, the admissibility hearing of the expert testimony, it is an avenue, as Munaf indicated, to not only fence in the opposing expert into discrete areas of examination, but you are eroding aspects of their testimony that even skirts the line of the scope of their refined expertise. So it's valuable to go through aspects of the qualification process, even though when you look at the CV, it's clear that this this is going to pass the threshold of a qualified expert, there's great value to chipping away a little bit during the qualification process. So anyways.
Yeah, and I couldn't agree more. That was the point I was going to make on the erosion piece. So yeah, I'll leave it at that. Thanks, Manaf.
Thanks. So let me sort of deal with one of what I think is the greatest mistake that gets made in cross-examining experts. Remember, just back to basics, the expert is providing the ready-made inference on a set of facts that must be proven. So many lawyers want to debate the factual basis with the expert. And so the expert's opinion will set out some factual thing, and the lawyer will fight with the expert to prove that that factual thing is wrong. And they'll take them to documents and other witness testimony, all of which in sort of my personal view is a huge and colossal waste of time. This is where you, the cross-examiner, have an incredibly powerful tool. The tool is called the power of pretend. And so what you do is, rather than debating any of the facts with the expert, you say, Mr. Expert, I understand your opinion is thus and so. Now, what I'd like you to do, sir, just for a minute, is pretend that just for a moment, that the facts are as follows. And then you do it in sort of gradations here, incrementally. And you say, now, sir, you'd agree with me that if you pretend the facts are as follows, that would be material to your opinion. Wait for them to say yes to that. If they say no when the facts are different, that just goes straight to their credibility. If they say yes, you then say, and sir, in fact, it may even, if the facts were as thus and so, it may even cause you to reconsider your opinion. And wait for them to answer that, because it's a reasonable thing. And then finally, you can say, and in fact, sir, if the facts are as follows, and I'd like you just for a moment to pretend that they are, you'll agree with me that the opinion would be X. And now you've got the expert right around. The expert can't fight with you. You've taken away the ability of the expert to fight on the facts. And you've saved probably the judge and the other side a day or two of cross-examination that would be completely useless in terms of arguing about the facts, all of which can be done in the final submissions. I'll pause if there's any comment on that. The other little trick I will just give you is another way of undermining the expert in the civil context. And I don't know if it's the same in the criminal, but when the expert takes the stand, they must provide you with their working files, and typically you'll get them in advance. Lawyers will agree to exchange. And the one mistake I find that many lawyers make is they provide transcripts to the experts because it's easy. So they'll give them the transcripts of the examinations of witnesses because it takes much more work to actually set out the facts. The danger in doing that is you've now turned the expert into a fact finder, which is not the expert's role. And so what I will do, and have done this a number of times, is if transcripts have been given to the expert, and you'll find it in their working files, go through the transcripts and find within the transcripts any contradiction of fact that exists. And I will say to the expert, you've had an opportunity to read the transcripts? Yes. And I gather the reason you wanted to do that was to familiarize yourself with the factual background? Yes. And so I just want to understand how you were able to sort this out. The witness said black here, and then the witness said white here. I gather what you did was you weighed that, and then you chose black or white in order to arrive at your opinion. And as soon as the expert has agreed to that, the basis of the report becomes undermined, because how do you decide what facts the expert actually relied upon when they've been left to their own devices to figure it out and weigh the evidence? So that's just a little trick, and I don't know if it works the same way in the criminal context.
I might add for the working files of experts in the criminal context, it's hit or miss as to when defense counsel will ask for the rough notes and calculations and things of that nature. For example, a forensic toxicologist. It's always wise to ask through the Crown in the criminal context of any rough notes or aspects of the working file of the expert in order to prepare your cross, because the glossy report is usually just the tip of the iceberg in terms of their processing, and it will help you in your cross to know exactly how they arrived at this final report. So.
And that goes back to the preparation point, right? So looking at the glossy report and expecting that to be the be all end all in terms of fodder for cross-examination would probably be in terms of knowing your file and knowing your theory of the case, you want to be able to access everything that you can get access to. And it's not the same in the criminal context, but there are rules and provisions in the code for those of you that are practicing criminal law that will allow you to get at some of these background and underlying documents. So make sure that you familiarize yourself as well with the law that applies in your case so that you know what you can access and what you can't. Thanks.
So I've been given the time warning, so I'll try and deal with the next few things a little more efficiently. Let me just offer one more little tip or trick when it comes to the issue of expert evidence. Remember that a witness that is qualified in any particular area is free to give expert evidence. In the civil context, the objection always is that you haven't had notice. And so the ability to call expert evidence is a notice issue to the other side, which is why the rules across the country have notice periods when you may provide expert evidence. I have, on a number of occasions, had the other side call a lay witness, and then in cross-examination, I've qualified the witness in a very subtle way. You start by, and I'll give you a quick example. I had a case where a witness was called to prove a factual issue, and this individual was also working at the energy regulator. And so after the examination in chief was given, I stood up and went through the person's background, their education, how long they had been at the energy regulator. And then I asked if they could be qualified as an expert to give opinion evidence on reporting requirements. Well, the lawyer on the other side objected and said he hadn't been given notice. I said, well, they can't give you notice about your own witness. And so this is not a notice issue. It's your witness. I've just happened to qualify them. They're qualified. And we carried on, and I was able to elicit opinion evidence from the witness. And it's something that's entirely proper to do. So just something that a lot of people don't appreciate that you can do because they're always worried about the notice issue. I'm going to turn very quickly to Brown and Dunn, and depending on time, I'll just quickly touch upon impeachment. So you've all heard about Brown and Dunn. It's a case from the 1800s. And Brown and Dunn is simply a rule about trial fairness. And the point is that you have to make sure that a witness is aware that their story is going to be challenged. That is, you can't sit silent, not put to them something of substance, and then argue in your closing argument that the witness was being dishonest. And so it doesn't require that you put every shred of evidence on which you might want to contradict the witness. You should essentially confront the witness with the matters of substance on which you seek to impeach the witness's credibility. And the issue is simply whether the tenor of the cross, or whether there has been enough notice given to the witness that their version of something will be challenged. And it may be that it's been raised in the opening statement. It may be that it's the tenor of your cross-examination is sufficient, that you've met the requirement, but you should be alive to the rule when you are undertaking a cross-examination. Maybe I'll just stop on Brown and Dunn because I'm sure you run into it a lot more in the criminal context than we do.
I don't know if Sona or Justice Ghosh, if you wanted to just add to any comments about Brown and Dunn.
No, just that I completely agree that you don't have to put every aspect of the opposing evidence that you anticipate to call, but provided key themes are put to the witness, as Munaf fairly summarized, it's a notion of trial fairness. When you make your final submissions, and you may want to craft how you approach the Brown and Dunn inquiry of the opposing witness, use very careful language. Sometimes you may choose to be cryptic, but so long as you comply with the rule in spirit, you're going to be okay when you reach final submission.
Great. Let me deal with just quickly impeachments. So generally what you want to do is you want to commit the witness to whatever the evidence was in chief that was given that you are going to try and impeach upon. So witness, earlier you said today that the sky was blue. So commit them to the evidence. And remember also under the and again, I'm talking about the civil context now, under the various evidence acts across the country, except for Quebec, you don't have to actually show the witness the previous statement that has been made in writing. You just have to draw their attention to it. Now, typically, when you're on the civil side, you've got a transcript of a examination for discovery, for example. You're going to use it. You're going to have copies available for the witness and the judge. And so there is a very simple formula, and it is a formula that you use to impeach in the civil context, and it goes like this. Earlier, witness, you testified that the sky was blue. Yes, I did. You were examined on November the 6th of 2019. My Lord, or Your Honor, examination for discovery, volume 1, page 42, line 42, question, what color was the sky? Answer, the sky was gray. Witness, you were asked that question and you gave that answer? Yes. You were under oath at the time? Yes. Don't ask the next question. So many lawyers do it. And that answer is different from the answer you gave back then. And now you've just undone, because I guarantee you 9 witnesses out of 10 are going to say, well, not really, because when I answered that question, what I was thinking about was a sunny day, not a cloudy, gloomy day. And so what I intended to, and now you've just gotten into an argument where the impeachment is gone. Don't ask that last question. Just leave it at that, and you'll argue it later. Say, remember the witness gave this answer during the trial, and this one, in fact, earlier, both under oath. And then just technically, if you want to rely on the version, whichever version, you can ask the witness whether the answer today is true and accurate, though I think that's more for textbooks than it is in practice. So that's all I have to say on impeachments. Thank you.
Thank you so much for that, Munaf. It was incredibly helpful. So now we're going to move on to Justice Ghosh. And I just want to remind all of the audience members, if you have any questions, please feel free to add them to the chat box.
Thank you, Divya. And we're targeting around 3:15 for questions. Is that right?
We've got until 3:20.
Okay, no problem. All right, first of all, my thanks to SABA and to my co-panelists and Divya, the moderator. I'm grateful to have the opportunity to participate in a panel such as this. So it's special. So first of all, I echo the guidance and tips you've just received from Sona and Munaf. They're, in my estimation, unassailable best practices and techniques, and there's lots to commend to what you've heard today. So forgive a bit of repetition, because there will be, but if anything, it will just reinforce and contextualize their observations to you, and that at least this judicial officer would be receptive, incredibly receptive to each of the approaches and tips that you've heard about. And hopefully it'll be also, my observations will ultimately be helpful to frame for you to keep in mind the ultimate goal of any cross-examination is to ground your final submissions in order to persuade the trier of fact, whether it be a jury or a judge or a panel. So I think Sona went through it very helpfully, that ultimately an effective cross-examination needs to be grounded in a coherent theme or theory of the case, which is propped up by detailed preparation and a granular, in my estimation, a granular knowledge of the entirety of the file. This ultimately, as you've heard both through Munaf and Sona, it permits a dynamic, focused, and organic cross-examination. You should know yourself, be mindful of the level of experience that you have, and you know, when you hear an incredibly experienced advocate like Munaf say, you know what, I drafted the precise words of my questions, that should be a signal that, and I know lawyers that have been doing it for 40 years, and many of them still commit to having a precise areas of examination, precise language drafted. Sona and I come from primarily a criminal context, a Crown context, where preparation is, in a traditional sense, is not readily available to Crowns, and that's a different muscle that you learn to exercise in conducting an effective cross, and it requires a skilled facility in being extemporaneous, going with the flow, and something that, as Munaf referenced, you're able to do, especially when you really know your file cold, and that's imperative in my view. So we've talked a little bit about having a concrete theory, and I think I referenced it earlier. It's okay to have multiple theories, provided they're complementary theories. And I can only encourage you to get rid of the fluff. Decide ultimately what this is really about. That can only come through, again, by thoroughly processing all of the evidence, including the fruits of any additional investigation you commission. I've talked a little bit about the merits of scripting your cross-examination where you can. There's immense value to that. As Munaf referenced again, the words matter, and especially when you're taking the witness to representations made on video or in transcripts or in documents, emails. You want to lock them down, especially when you're impeaching them. Don't give them wiggle room. Again, it's about control. One of the challenges in being, you know, and really it comes down to your comfort level. You may say, I will outline various areas of cross-examination. I'm comfortable enough that I can go with the flow. If I'm too scripted, I feel I lose some of the magic of cross-examination, my ability to really listen and to zero in on things that are being said and to redirect when the examination is going in a certain direction. And as Sona referenced, sometimes just listening can open up a world of opportunities in cross. So you have to be flexible. And much of this comes with experience. The more opportunities you get to cross-examine, the more comfortable you'll be deviating from any draft script you have going. But you have to be prepared to deviate from any script. Things will go awry in cross-examination. And you just have to presume you're working with an adverse witness. That's just the nature of the beast. So something to bear in mind, trying to combine an approach that involves preparation and precision of language with the ability to be extemporaneous. That's sort of an ideal, but there's all sorts of approaches, as both counsel have referenced. I'll talk a little bit, because Munaf helpfully discussed the unruly witness, the difficult combative witness, which in every context you're going to face, especially in cross-examination. I can't improve on his observations, they're bang on. I'll speak a little bit about vulnerable or sympathetic witnesses. In a variety of contexts, they'll arise: civil, family, criminal. So obviously, you're going to want to read the room when you're dealing. And in the criminal context, I'll speak about sexual assault complainants or child complainants. And you want to have just a basic sensitivity to social norms and how they can impact how the tone of your questions might be received or perceived by the court. So obviously, you don't want to sacrifice your duty to your client. You want to be a fierce advocate at all times, but you're also there to persuade the trier of fact. So you want to be tonally sensitive to the sympathetic or vulnerable witness. It's strategically valuable, but it's also just human, and it furthers the interests of your client to take such an approach, in my estimation. So, and also when you're dealing in the criminal context, as one might appreciate, and it's all over the news, especially with sexual assault cases, you want to be sensitive to the prospect that the judge may recognize that we are dealing potentially with a true victim of crime here. In fact, it's likely that the operation of the law, a combination of the presumption of innocence and the reasonable doubt standard, may require an acquittal here. So just be sensitive to that dynamic that the judge may be grappling with in terms of the tone of your questions, taking an accusatory approach, and the case at hand may call for it. But it would be a rare case, for example, with a child complainant of a sexual assault, that you don't use careful language and you're not mindful of your tone in the way you cross-examine. You'll use just something to bear in mind. Another thing when you're dealing with sensitive witnesses or vulnerable witnesses, being kind, again, provided it's not sacrificing the interests of your client. It goes a long way to engendering good faith with the trier of fact. It's also strategically valuable because you can convert an otherwise adverse witness into a receptive one. For example, if you know that there are facts not an issue, don't leave the witness hanging. You can let them know, look, we're not here to debate that something happened to you. That's not an issue at all. I want that understood right out the gate. This is strictly about your identification of my client. And again, the timing of that's key as well, because you may wish to chip away at the reliability of their identification, but it's how you approach it. Again, being human will go a long way to effectively advocating for your client. Munaf spoke very helpfully about impeaching witnesses. So I'll talk a little bit about video recordings, and this might assist in your preparation. Early on in the process where you can, there are video recordings, whether it be statements or police station videos, in-cruiser camera recordings, lapel mic recordings by the police. Get those transcribed where you can. It assists in your preparation of the file, and it also greatly assists with the ease in which you can navigate the cross-examination. And of course, if there's some dispute about what the transcript reveals, you always have the recording at your disposal. But there's nothing like losing momentum. There's nothing that causes you to lose momentum more than having to queue up a video in the middle of a dynamic cross-examination and having to find the right spot. And it happens more often than it should. You give the witness a chance to gather himself or herself. And as both my co-panelists have observed repeatedly, you want to maintain control and, where possible and appropriate, keep them off kilter. So you don't want to give them a chance to gather themselves. The kitchen sink approach to cross-examination. So some lawyers choose to leave no stone left unturned in cross-examination, no matter how trivial the point they might be attempting to establish. There may be occasions where it's called upon to go in depth into every conceivable area. For example, where you're attempting to chip away at the reliability and credibility of a witness. you may have to slowly and procedurally go through a number of less apparently key, less central points. You just want to read the judge when you find you're getting into collateral areas. I'll talk a little bit about paying attention to the trier of fact shortly, but something to bear in mind. Just keeping an eye on the time. I know I have a few more minutes, but phrasing your questions. Both of my co-panelists have talked about it. Really, you want to keep where possible short, one fact questions, clearly worded. Again, you're doing your best to extract and confirm facts. Confusing the witness should never be the goal. Aside from the diminished weight attached to confused responses, you risk also confusing the trier of fact. You don't want that. So again, leading questions for the most part. The goal is to retain control, and a well-timed open-ended question after you've locked down key surrounding facts that make the question, as Sona intimated, almost rhetorical, can be a very powerful advocacy tool. So something to bear in mind, that you don't have to be committed to only asking control-oriented leading questions. I was going to talk a little bit about different means of organizing your cross, but I don't think I can improve on what Sona has relayed to you in her distillation of the various options. So I'll leave it at that, and maybe we can field some questions. Thanks, everyone.
So Justice Ghosh, I do want to say that you've got a few more minutes here. We don't have too many questions yet from the audience. If there's something else you'd like to touch upon, please go ahead and take the time.
All right, let me see. I think I'll flesh a little bit out the prospects on the manner in which you can structure a cross-examination. And again, it's something you want to be conscious of. You want to think about it. And you want to have a defined approach. Don't leave it to chance. Don't construct a cross-examination in a sort of haphazard way. So you may want to pursue it, as Sona referenced, in a chronological fashion that contributes to a narrative cohesion in your cross. You may want to impact the witness early on with a powerful point of contradiction or impeachment, just to derail the momentum that was achieved from their examination in chief. Or you may want to close with your most powerful points, or you may want to have pillars at the start and end. But just turn your mind to it, because it's difficult where if you choose to jump around from area to area, which is also fine, just make sure that they're issue-driven bundles of questions, because you are going to lose the trier of fact if you're all over the place, despite being well prepared. So something to keep in mind. So I'll end with a couple of observations on reading the judge. It's something I did my best to do, to be aware of the jury without staring at the jury, unnerving any jury members, or unnerving the judge by staring at them. You don't want to do that too often, but look up once in a while and get a sense of the judge's body language and verbal, nonverbal cues. You know, that won't necessarily determine your approach, but it might inform whether or not you're going to delve very deep into a collateral area that the judge finds not helpful. The judge asks, where are you going with this? Or I'm not seeing how this is relevant. That doesn't mean you necessarily stop. You can respond to the objection. If the objection goes your way, you may want to recalibrate how deep you go into this area that the judge obviously doesn't think it's as important as you once thought. So just be dynamic in your approach, and listening to the way the judge disposes of objections. You may or may not like the approach. You may even see a theme that seems adverse to your approach. Just be flexible, because you'll serve your client's interests ultimately in reading the judge and the manner in which they attend to submissions, objections. And if you've got a judge that doesn't appear to be responsive to your approach, that's it. Just the ability to modify on the fly is just something I would encourage you to do. So I'll leave it at that.
Thank you very much, Justice Ghosh. So we have time for a couple questions. So I'm going to start with one that's coming from Andy. So I'm going to pose this first to Manaf, but please, Sona and Justice Ghosh, feel free to add your insights as well. How do you deal with a judge who interrupts and asks, "Why are you asking that?"
Sure. So it depends on what the question is. If it's something that's sensitive to the cross, what I will typically do is ask the judge if we could excuse the witness. And I'll have the witness leave the courtroom and say to the judge, look, here's the issue, here's where I'm going, and I need to establish thus and so. So that it may be, and you get judges that are very active. And another thing I've done with judges that are maybe very, very active, where, you know, there are judges who have done this so many times and they know how to do it better. And a lot of times I will just say to the judge, say, you know, Your Honor, my lord, my lady, I wonder if you'll just permit me the opportunity to persuade you that my position is accurate in respect of this, that, or whatever it is you're arguing about. And when you typically do it that way, the judge will back off and give you a little bit of space. So that's typically how I would deal with it.
Sona, do you have anything to add to that in the criminal context, perhaps?
Yeah, so agreed completely with Munaf. Excuse your witness. I also make sure that there's an order excluding witnesses, or if there hasn't been one, or if I see family members or witnesses, other witnesses in the courtroom during that question from the judge, I do ask the judge if members of family members and or other witnesses could be excused, just because I trust nobody, and I worry that perhaps the strategy may be conveyed, whether they're supposed to or not. So I just play it safe, and I do ask that others be excluded. That doesn't always get granted, but at least I asked, and I can sleep at night.
Thanks.
First of all, I don't think I've ever asked that question. Why are you asking that? And part of it comes from, and I'm very mindful that there are judges that are quite interventionist during cross. We should be acutely aware of a very expansive right to cross-examination. Supreme Court's expanded on that repeatedly, and the judge should be aware that you know the least about the case in the room, first of all. I'm acutely aware of that in every case, which is I'm not even sure if I've recalled asking counsel, what's the relevance of that? Because as soon as that pops into my head, and sometimes it does, I'm wondering, this may not seem that helpful. If I don't field an objection from the other side, my instinct is to basically shut my mouth and listen. I'm there to listen and process evidence, and to intervene in the fashion that was described. And again, I know it happens, so I'm not under any illusions. It's happened to me as counsel. Do exactly what Munaf and Sona indicated, knowing that, you know, you have a judge that's intervening perhaps in a way he or she should not, because you know it's clearly you've got an area of relevance that you need to pursue. Exclude the witness, be diplomatic, knowing that this is the person that you're ultimately trying to persuade, and recognizing that, uh-oh, I might have an uphill climb here because he's thwarting a key area of examination. There's not much to be done about that, but it's really how you respond to that. And you know, best practice for judges, and I share it with new colleagues who join, is just learn to let go of your advocacy muscle and just be receptive. Listen, because you don't know the file like they do. You just don't. I think bringing some humility and trusting counsel that they're doing their best and know their file I think that's maybe an ideal that I aspire to. Yeah, I think that's exactly the way to handle it, the way Munaf and Sona suggested. So.
Thank you, Justice Ghosh. And I can speak from personal experience having appeared before him. Don't be fooled, he's one of our kinder justices. So.
Thanks.
Okay, well, thank you so much. I want to thank our panelists so much today for being with us. It's been really helpful. I can speak as junior counsel myself. These are very, very helpful practical tips. I know we've just scratched the surface of cross-examination. So thank you for doing kind of a speed lightning round on all these very, very important topics. And I also want to just let everyone know that on May 20th, SABA Toronto is having a social, and on May 5th is the next session of SABA's advocacy series on closings, written materials, and experts. So May 5th, the same time, 2 p.m. Eastern time, and you can register. So on the SABA Toronto website, please feel free to do so if you enjoyed today's webinar. And again, thank you so much to Munaf, Sona, and Justice Ghosh for your valuable time. It's greatly appreciated.
Thank you.
Thank
Thanks,
you.
everyone.
Stay safe,
Good
everybody.
luck.
Pleasure.
Bye.